Hello and welcome everyone to the new state data privacy laws, your questions answered. I'm Scott Giordano. I'm general counsel at Spirion, also our vice president of corporate privacy and all things privacy and security. And so for the next hour, we're going to spend some time together talking about the 5 new state data protection laws that are coming online in the new year. So without further ado, let's get right into it. So here are the things we're going to talk about today. And we're going to not necessarily get through everything, but I'm going to get through as much as we possibly can. Not surprisingly, this is here for you and for your questions. So send them in. I will answer them as they come through. So if you leave with nothing else today, I want you to leave with these 4-ish things. First up is the CPRA, which is California's updated data protection law, going live January 1st, creates a default national privacy standard. And I'll tell you more why about that during our presentation. The 4 other state rights-based privacy statutes are very similar, but there are some noteworthy differences, and I'm going to focus on those, not surprisingly. Many of the principles that all of these statutes embrace are borrowed from GDPR. And then finally, not surprisingly, understanding where and what qualifies as personal data within your network is crucial, as is who has access to it. So let's dive right into it. So some key dates. So here are the key dates for when these laws go live. Now, there is a quote-unquote grace period for the CPRA, and that is to say that it is enforceable on 7/1/2023, so the 1st of July. Keep in mind, though, that the law is live, and the look-back period for the CPRA is 12 months prior. So any data that has been collected or processed in the prior 12 months is in scope. So keep that in mind. That is a gotcha, and I'll talk about gotchas as we go through this. You can see the other dates as well, so they are throughout the year, but on the beginning of the year, we'll have both California and Virginia's laws going live in July, Colorado and Connecticut, and then finally we'll wrap up with Utah. So, what's common to these laws, and I won't be spending a lot on what's common to these laws, rather it'll be what's different, but what's common. So they all apply, for the statutes anyway, exclusively to businesses. Now, Colorado is going to apply theirs to nonprofits via rulemaking, but that really is more or less an edge case. All of these apply to businesses outside of their respective states. That's a question I get all the time. God, does this only apply to companies within a given state? The answer is no, it applies to everyone. Also, all of these laws address what we call sensitive or special information, and that has different meanings, not surprisingly, but we'll dig into that. All of these statutes require consumers to opt out of marketing, of regular marketing anyway, as opposed to, say, marketing involving special personal data. We'll dig into that. They all mandate information security controls and risk assessments. Some do it implicitly, many do it explicitly. Also, they all mandate that these controls get imposed, and I use that word very deliberately, imposed on service providers and contractors who by now are likely very savvy about this. They give a consumer a right to access and delete their personal information in all cases, and they require transparency on how personal information is processed. So that's what's common to all these laws, and we'll discuss what transparency, by the way, means as well. It can mean different things to different people. So what's different? These are the things that are different about the laws, and I'm going to just dive right into them rather than go these one by one. So let's talk about what I call in-scope information. So in-scope information meaning the kind of information that these laws were designed to address, and more importantly, information that you likely will care about. So you've got 2 big buckets of definitions of personal information. So under CPRA, you have a very lengthy one that talks about information that's reasonably capable or could reasonably be linked to someone, or is reasonably capable of being associated, or is reasonably linked. And you might ask out, why does the word reasonably appear so much? And it does because lawyers love the word reasonably. So that's why it's there. I can't really think of a better reason. For non-CPRA, you'll find that they simply use reasonably once, and it's a very simple information that's reasonably linked to an identified or identifiable information. Again, borrowed more or less from the GDPR. So that's the definition. Okay. But the nature of personal data has changed. So when GDPR got off the ground, you had what I call regular personal data. So the kind of thing that we all just expect is personal, your social security number or your phone number or what have you. Also including machine readable data like your IP address. And then they added this idea of special personal data. So things related to your health or your political religious affiliations or trade union membership, et cetera. So that to them, and still is, personal, special personal data. Well, comes along the CPA right after GDPR went live, and it added all kinds of categories of information as personal data, including things that would qualify under the EU as special data. So it didn't really use this idea of special data. Then comes along the CPRA, which then adds special data. So you have special information like your government issued ID, genetic data, etc. So you might ask, well, why does any of this matter? So, well, here's why. So first up, California special personal information. I'm highlighting this because this is important for a variety of reasons. So you have things you would expect would be highly personal, like your social security number, your driver's license number, account login information. What's interesting, two things are interesting. One is a consumer's precise geolocation, okay? That's special personal data. Also the contents of your mail or email or text messages, what have you, unless the business is the intended recipient. So if a business is a medium between two parties, then that data is considered special. So you might wonder, why am I highlighting geolocation data? Because geolocation data is the high fructose corn syrup of personal data. That is to say, it is in everything, and it shows up in places that you likely would not have expected. So the net of it is that a lot of personal data is special personal data under California's new law. As far as other kinds of quote-unquote special personal data, things you would expect, again, will be special. So genetic, biometric, things relating to health, sexual preferences, et cetera, et cetera. So no surprises there. So what's interesting here now is that if we talk about what's in scope, so you have all of these special areas under California. They're not necessarily special under the other laws, but they almost certainly qualify as regular personal data, which means they still have to be accounted for. And certainly if you had a problem, for example, with exposure to someone's precise geolocation, there's still going to be plenty of problems with it, aside from it not being necessarily special in California, for example. Also, the things that you would consider special in other states are, so biometric, health information, sexual preferences, et cetera, et cetera. So not terribly surprising. So as far as in scope as information, things that perhaps you may not have thought would be special are special, but everything that you've seen thus far is personal. Okay. And then finally, for California, two things that are in scope that are not in scope for others, and that's employee data. And that's not just employees, that's job applicants, that's contractors. Big deal. And then also we have B2B communications, which not terribly controversial. The net of this is that this has been a bit of a political football over the past 4-ish years as to whether these things are considered personal. They are now definitively personal, and they are therefore in scope. Okay. So children's data, talk about children's data. I have a question coming in though. So let's see, let me check the question section and see what we got. So hang on, folks. Okay. Do law firms that have personal information of clients and litigants have to be compliant? Absolutely. Yes, there is no exception for law firms. I'm sure the legislators probably would have liked law firms to be accepted, but no, law firms don't get a pass. They are just as subject to these laws as the rest of us. Okay. And then to close up this idea, children's data is sometimes special personal data, not under CPRA or Utah's law, but still in any event, parental consent is needed. So as a practical matter, whether it's quote unquote special or not special, you're going to find that children's data requires essentially a lot more scrutiny than it would otherwise. Okay. So as a practical matter for in-scope information, create or update, hopefully you have a data inventory, but please do update it. And then also put a priority on sensitive personal information that we just discussed. If you're in California, identify employee data or business-to-business data, and then identify special personal data that's being used for marketing. And we'll dive into marketing in just a moment, but that is one of the big issues, if you will, that is addressed by CPRA and largely by the other laws as well. Also, if you have more questions, roll them in. So talk about the limits of the use of in-scope personal information. So just in general, many of the limits that we're going to talk about are really focused on advertising and marketing. Not all of them, mind you, but a lot of them, because that was a big concern. So the idea of limiting personal information to just what you need as a business, limits on what's called cross-context behavioral advertising, which is really targeted advertising writ large, and then the idea of opting out for targeting and for profiling. So this is just a tacit recognition that data science has come a long way, and that it's very easy, it's shockingly easy to infer personal characteristics and to identify persons. I'm continually shocked, and I do this for a living. I have a question that just came in. So that an app that tracks an employee's GPS in order to reimburse for mileage is now collecting personal data? Yes, it is, full stop. Okay. Why else do we care about special personal data, and why am I harping so much on it? I am because under CPRA, individuals can tell a business, hey, you must limit my personal information. Businesses must limit the use of special personal information. And if they're not going to, then they have to put a link up on their website allowing you to click on and say, limit the use of my special personal information. And here's a fun experiment all of you can try at the first of the year, is to plug in, limit the use of my special or sensitive personal information into your favorite web browser and see what pops up. My guess is a lot of businesses are not going to want to be able to address this, and they're just not going to use SPI to begin with for anything other than the bare minimum. Also, consumers have to opt out of the sale of your SPI under CPRA, and it cannot be used for CCBA for essentially targeted advertising. So we'll dig into that. By the way, what qualifies as a sale? Because a lot of the discussion here is about prohibitions or requirements to opt in for sales, for example. Under CPRA, sale is just about anything. So if you are renting it, selling it, giving it away, disseminating it, etc., as long as it's going to a third party and it's for money or other valuable consideration, it's a sale. But if you're sharing it for targeted advertising purposes, TCBA, then even if you're not getting any money or consideration, that's a share. So it's a very low bar to clear. So again, more about CCBA, because this looms large in CPRA. So it's a targeted advertising, and it's across businesses or distinctly branded websites or applications or services. The idea is that essentially it's collating all this information among distinct websites that you wouldn't as a consumer associate, and you're building that that dossier, if you will. And so in California, you can opt out by clicking on the do not sell or share my personal information. And this should be a relatively common link that you should all be seeing. Again, plug that into your favorite web browser and see what comes back. Other statutes in the other 4 states don't use the phrase CCBA, but they do allow you to opt out of targeted advertising. And in particular, 2 states, Virginia and Connecticut, if you're doing targeted advertising, that implicates the necessity for a risk assessment. We'll talk about risk assessments shortly. And folks, if you have more questions, send them in. Okay. So profiling, is this the same as profiling? Not exactly. And a lot of this idea of profiling was borrowed from our friends in the EU. So you have this idea that you're going to have automated processing to evaluate personal aspects of someone and predict things, their performance at work, their economic situation, etc. So that is profiling. So arguably, it's not the same thing as targeted advertising, but they're related concepts, arguably, because one can inform the other. So in terms of limits, the California Privacy Protection Agency, the privacy police that I'll talk about, right now that's to be determined what limits are going to be put on it. Right now, there's just no use of SPI for profiling, full stop. Excuse me, the other states offer, for the most part, opt-outs versus profiling. Okay. Again, what qualifies as a sale for other states? It really depends. So in Virginia, Utah, if you're just offering data for money, that's a sale. In other states, Colorado, Connecticut, it's data for money or other valuable considerations. So again, just different approaches in the different states. So your task list here, identify third parties to whom you're selling this kind of personal information and what are they doing with it. If they're doing advertising and marketing, again, this is going to precipitate a complete, if you will, top-down review of exactly what's being done with it, what information is being used, under what legal doctrine. That is to say, is someone being given an opportunity to opt out? Is special data being used, etc. So all that has to be determined. Is your business using CCBA? And if so, incorporate that into the data inventory, into the other processes that you have to at least identify that data is in scope for that. And then locate all the agreements you have with third parties. And you might be wondering, why am I spending so much time on third parties? I am, because they're the ones that will get you into trouble the most. It's just when you license things to third party, unfortunately, you tend to lose control of that data, even though you have a contract and they get into trouble. Cambridge Analytica is probably the best example of that at this point. Okay. So jurisdictional scope, this is another question I get a lot about, so I wanted to dig into it. How can you be subject to these laws? Well, in general, government agencies and nonprofits are not subject. Again, there is an exception potentially in California in some edge cases. I'm not going to dig into that. And there will be some to nonprofits in Colorado, but by and large, this is really geared towards businesses. Also, certain businesses like healthcare and financial are either given a full exemption or the data that's in scope is given a full exemption. So for example, CPRA doesn't exempt healthcare, it doesn't exempt financial institutions. It just says the data controlled by, for example, HIPAA, HITECH, or GLBA, or other federal laws for that matter, get a carve out, okay? But these businesses have plenty of their own laws to deal with. And in fact, GLBA was just updated and it is very, very rigorous compared to what it used to be. Also note, and this is important, is that this applies to all 50 states. So for example, if you are a company, it's not one of the 5 states we mentioned, but you're processing the data of folks in California, for example. You are now in scope, assuming that you meet the other requirements, you're now in scope to be subject to this. Also, this applies in theory outside the US. So if you are in Canada, if you're in the UK, and you are developing websites or targeting information to the US, to those specific states, those specific consumers, then you're likely subject. That hasn't been litigated yet, but likely you are subject to that. So subject to the law under CPRA, I'm going to use this as the model because I think this is really perhaps the best model of all of them in the sense that it's the easiest to become subject to, believe it or not. So you have either you're conducting business in the state, okay? And if you're conducting a business in the state and you've got 25 million in revenues, or you are processing more than 100,000 persons worth of data, or you get more than half your data from selling personal information, then you're subject to CPRA, which is a pretty low threshold. Because you think about it, if you're, for example, a startup, and you have a web app or just a regular phone app, and you are selling personal data in exchange for the product. Okay, so it's a free product. It's supported by advertising and by selling people's personal information. That's very easy as a startup for you to be subject to this law. So a good example there. Also, the 25 million threshold is for worldwide sales, so not just for things that are in California. Again, that expands who is subject to this in California. Okay. Other states. So generally speaking, the model is the same in the sense that you either conduct business in the state, you target goods or services towards that state, and then you either make the revenue threshold or the volume of data processed, or you get revenue from the sale of residents of their personal data. So some of these are either ors, some of these are ands. Like, for example, Utah has a higher bar, for example, than California in that sense that it requires a couple of these things. So the net of it is that you're going to have to look at each individual state and look at the threshold. As I like to say, if you're watching this webinar, you're probably subject to these laws regardless. Also rulemaking, just to touch upon rulemaking. So both California and Colorado have rules. California, as you probably know if you follow this, is on their second update since the California Privacy Protection Agency went live. There's a public hearing on December 16th, in fact, so next week. When is this? When are the revisions going live? I don't know. We hope in January or perhaps February at the latest, but we just don't know. Colorado, the comment period is closing in February 1st, so there's still time for you to comment on them, and they go live on July 1st. As far as other states, I'm not aware of any states making rules. I would not be surprised if they did so because this is such a complex topic. So on your task list, confirm the conduct of business in or direction of sales or marketing to these states. By the way, whenever you hear the idea of directing goods or services into a jurisdiction, that's copied right from GDPR. And then determine if any of the thresholds have been met. As I said earlier, if you're a startup, you're relying on some kind of a freemium model, or even if you're a regular business, but you have this internal project that relies on freemium business models, keep in mind that's going to make it very easy for you to otherwise be subject to law. Okay. Talk about new consumer rights. So there is a core set of rights that I suspect you're all familiar with just by the nature of the way these laws work. So, and by the way, I refer to these laws as rights-based data protection laws. And I say rights-based because individuals have a certain set of rights that have to be complied with, full stop. You don't have this ability to say, you know what, that's too much work, or no, I don't really want to do that, or whatever. It's a right for this person, and you have to give the data to the person. Hence, rights-based privacy law versus a risk-based one. Like, for example, you think about the old, I guess the current HIPAA or GLBA tend to be much more risk-based, for example, than rights-based. So the core rights: get a copy of your personal information. I refer to those as DSARs, data subject access requests. Sometimes they're called subject rights requests, but the net of it is that it's a give me a copy of whatever you got on me question. You have the right to amend or correct, Utah being the lone exception in that. Not sure why, but I suspect we'll fix that. You have the right to delete in all cases. You have the right to opt out of sale, or in some cases, at least California, sharing. And then you have this idea of portability. That is to say that whatever is sent to you has to be in some kind of useful format, like a Word document or an Excel file or something like that, or maybe a PDF. So response time. So here's the thing. 45 days is your limit to respond, to do whatever that it is that you need to do to get a copy of their data to the person. You can potentially get a 45-day extension for cause, but I would not push that if you did not have to. In California, it requires an acknowledgement within 7 days that you've received the request. Frankly, that's a great idea for everyone. I recommend everyone acknowledge within 10 days, if not sooner. And then honor opt-outs within 15 days in California. Again, I think that's a great standard for everyone to adhere to. Here is the challenge, is that unfortunately there's numerous exceptions to these, especially under CPRA, which is sometimes maddening. So they have this one exception that is really funny. You could tell a lawyer wrote this. So to enable solely internal uses that are reasonably aligned with the expectations of the customer, the context of the relationship that's compatible, blah, blah, blah. So what does that mean? Frankly, it can mean anything. So that is a concern that a company could say, you know what, we're using this solely internally. This is consistent with your understanding of how we're using it, blah, blah, blah. So that is a problem. That is a potential. By the way, GDPR doesn't have anything like that. Basically, you've got to cough it up unless there's some majorly extenuating circumstance. So a big difference. So opting out and opting in, this is a job in and of itself to maintain what you have to opt in and what you opt out of. So just in general, you can opt out of sales of your personal information or sharing of your special personal information, of targeted advertising and profiling for the most part. Again, there are some that Utah has some limitations, but by and large, that's it. They can opt out of those kinds of things. Typically to opt in, it's going to be sale of SPI or processing of it or sale of children's data or sharing of children's data. So that's generally speaking what has to be opted into. So this is again in contrast to how GDPR does it, which is pretty much opt-in for everything. So just a different way to approach. Also, other consumer rights, other states use the same model. They're very consistent with CPRA. And as I said earlier, there's no right to amend for some reason under Utah's law, but I suspect they'll fix that. That is probably just an oversight. It doesn't make any sense to be able to delete it, but not to amend it. So again, your task list. Do an internal review, determine if you have the ability to even do in good faith the subject rights requests. I know that in many cases, companies think they're ready to do it, and then they get a request and they realize that maybe they're not quite there yet. Also determine who's going to be your front line. Will it be customer service? Will it be a special line? Will it be just a special email address? Will there be a chat bot? How are you going to record the information from the chat bot? It goes on and on. So do that ahead of time, because again, people are going to ask, well, I requested this through your chat bot. Where is it? And if you can't find it, then that's going to be a problem. Do establish a ticketing system or a tracking system. You probably have one for other things. Probably getting a copy of that and doing it just for your opt-outs and for privacy-related matters is a good idea. Do develop policies to address hard questions. So some consumer is convinced that you've got data about them. You say you don't, they say you do. How do you resolve that? Because you know they're going to go to the authorities anyway. And then also in California, note that there's going to be conflicts with employees, because employees are going to be able to say, I want a copy of all my data and I want to delete it. And that's the problem with that, of course, is that you may have multiple reasons why you have to keep that data. So that's the net of it. If you have questions, please send them in, folks. New business obligations. So in general, these are the things that businesses have to do. You have to offer transparency in your collection and processing of personal data. And I'm going to dig into that quite a bit. By the way, this is not a privacy policy. Please, in fact, if you'll just erase the whole idea of privacy policy here. Privacy policy is something that's internal to you, not something the public's going to see. You'll have a privacy statement, you'll have a privacy notice, but there's no privacy policy. Also, responding to DSARs or SSRs, being able to do that, honoring what's called global privacy controls. This is going to be a big challenge. And then things like data minimization, record keeping, et cetera, et cetera. So we'll talk about those in short order. Okay. So transparency. Really what transparency means is that you're helping consumers understand what personal information is being collected, how it's being used, and with whom it's being shared. And I emphasize how it's being used, because this was a challenge that I had advising clients way back when GDPR was going live, was how are you articulating the use of the data? You may have 20 different uses for a piece of data. Are you giving them all that degree of specificity? Or are you being very general, too general, so they can't really understand what you're doing with their data? So it's a very, it's a challenging thing to write, to say that you're going to do these things with personal data, but making it general enough that you are not painting yourself into a corner and you can do the uses you want, but not so specific that once you've done it, people really can just opt out and choose what the things they want to opt out of. So it's very frustrating in some cases on how you articulate this. And this is a policy decision. It's not just a lawyer decision. Also, in California, you have to notify consumers about automated decision-making. If you go to websites of California-centric companies, even though all companies really should have this, you'll find they talk about automated decision-making. And then also the other laws offer opt-outs versus profiling, as we mentioned earlier. So helping consumers understand their rights versus businesses from a given jurisdiction and exercise meaningful control. I copied that right out of the California privacy regulations. And so this is the idea that you want to have people understand what you're doing with your data. And if they don't like it, or they want to make changes, they can make changes. That's the idea of exercising meaningful control. That's really what should be your ultimate goal here. And under California, there's all kinds of mandates. And those are the ones that I'll be drilling down into, because you really can use those as your standard. So transparency, what do we mean by transparency? This is a list of some of the things that will likely be on your transparency list, in the sense that these are things you're going to address. So like collection of the personal data and all the categories and why, and whether you're selling it to whom, all these things, the kind of information that folks would want to know in order to make meaningful decisions about whether you continue to use their data. Also then giving them a list of their rights. So you have a right to amend, you have a right to opt out, etc. That's what we mean by transparency. Also, one thing that is probably relevant more so now than it was, say, 5 years ago is cross-border transfer. So, for example, when I work with folks in Canada, they want to know, is their data being stored in Canada? Is it being processed there, or is it being processed here in the US? So you want to be able to apprise folks of that as well, because there are some narrow cases where it simply cannot leave Canada, as an example, and the same certainly is true in other countries. There's also a separate but related issue on transparency called the point of collection. And this is enough to absolutely make your hair stand on end when you think about what you have to do here. You have to not only have a privacy statement on your website, like everyone does nowadays, but then at the point of collection, so where you're going to, as a consumer, plug in information, then you need to be able to give very specific information about what's being done. So what categories are being in scope, what the purpose is it being sold or shared, etc. And the question is, well, how does that look like? Is it like a floating bubble that pops up when you put your mouse over the fields, or is it something else? And there's really not a good answer. I tend to just put a link right by where the collection point is, and then have that go right to the relevant section of the privacy statement. But the net of it is that this is tricky. It's something that you cannot take for granted. It's going to require some effort to be able to make it work. Other obligations. So responding to DSARs, you've got, as I said earlier, 45 days plus 45 days for cause. I wouldn't, again, push that if you didn't have to. Also in California, have to acknowledge within 10 days, and you've got 15 days to honor opt-outs. Frankly, that should be the standard for everyone, as I mentioned earlier. Global privacy controls. This is going to be a big challenge. So a global privacy control is a signal that your browser will send whenever you go to a website, and essentially says proactively, don't sell my information. Now, again, I'm being very general, but this is how it's going to work. And so the idea is that you have to, as a business, be able to detect these signals and automatically opt out someone. This is not surprisingly very new, not conceptually, but it's very new technologically. And this is something that the California privacy regulations are pushing hard, but others are picking up as well. I don't have a good answer for you on how to address this. This is, again, just going to be an issue that has to be addressed in some capacity. Also, data minimization. So you have this idea of data minimization. That is to say, you're only going to use the bare minimum data that you need to do the job. Sometimes it's just flat out mandated. Sometimes it's just implied. So the regulation of the law will say, use only as much data as you need. Whenever you see need or necessity, keep in mind that that's just straight up data minimization. And then data retention destruction, same idea in the sense that you only keep the data as long as necessary. Now, you're probably going to say, wait a minute, Scott, I have all kinds of requirements. I have broker-dealer requirements to keep data for 7 years, or I have this requirement. Yes, those requirements will take precedence, but let's say that you're a retailer, okay? And perhaps you're a web-based retailer. You're going to look at all of the regulations that you already have, whether it's from the FDA or whoever. Those will typically govern first. Then anything that's left that's out of scope for those laws, then those are the kind of things that you would want to keep as necessary. Also, record keeping under California's laws, you have to prove you've complied with consumer rights, and you have to keep records on this for 2 years. So just to think about this is something that frankly you should be doing for all states, because potentially any of them are going to ask you, hey, so-and-so asked for the records to be deleted. They're not deleted. What happened? And so either you have a record that you've complied, or you have a record while you haven't. Maybe that there's an exception because there's pending litigation or government investigation, and they've asked you not to eliminate that data. For example, if you have a breach, typically the government will tell you, don't delete anything, don't change anything, wait till the investigation's over, don't notify anyone until we tell you to, etc. So keep in mind that that's going to take precedent. So on your task list, develop a very refined understanding of what personal information is. I've been talking about this whole hour, but it's very, very, very important that you develop this understanding of what qualifies as personal information. and what you're doing with it, with whom you're sharing it for any reason, okay, because the people with whom you're sharing it are the ones that are creating problems. And then what are they doing with it? Because for the same reason is that you typically have a better idea of what you're doing with personal data than what others are doing with the data you license to them. Again, I'm using Cambridge Analytica as an example here. Add to that, how long have you been keeping the data and how long do you really need it? So it may be time to go to, say, product management if you're collecting consumer data based upon your products and asking them, how long do we really need this data? Can we potentially even de-identify it if we still need some essential elements of it? Also, develop an ability to prove you've done what you said you've done. So this is the thing, is that reporting is so important to be able to show a regulatory agency, hey, someone asked me to delete this. I couldn't because of XYZ reasons, and put together a log. Okay, so those of you familiar with, say, privilege logs or something like that in litigation, same kind of idea, is that essentially you're creating a log of everything that you've done, and then you're able to share that with an authority. That's the kind of thing that potentially is going to be very helpful to you to prove that you've done what you said you actually did. Okay, so talk about information security. So information security, a big challenge for all of us, given the prevalence of things like ransomware and malware in general and 0 days and all those fun things. So talk about how these laws address that. So again, I'm going to go to CPRA because that really is leading the way here. So CPRA has this positive mandate that says that you have to use reasonable security procedures and practices that are appropriate to the nature of the information. So reasonable security procedures and practices, that's going to be controls. That's going to be your administrative, your technical controls, your physical controls we put in place. Appropriate to the nature means risk assessment. Whenever you see appropriate to the nature or some language like that, it means there's an implication that you've done a risk assessment. So keep that in mind, that even if they don't use the phrase risk or assessment, it's a risk assessment. Also, in California, they've added to the list of things that are in scope this idea that an email address in combination with a password is now in scope. So think about how many times email addresses with passwords wind up on the dark web. It happens with regularity. Now, all of those instances qualify as a breach effectively. And again, they implicate this law, they implicate the idea of a private right of action, which I'll talk about in a minute. So it also identifies this idea of significant risk businesses. So what's a significant risk business? That's a great question. We don't know yet. We do know that the California Privacy Police, essentially, the privacy agency, is going to put together very specific rules on what qualifies as significant risk. But suffice to say, if you're processing special personal information, you are likely to be implicated as significant risk. Question just came in. Is ISO 27001 CERT considered a reasonable security procedure? It is considered reasonable under the circumstances, but here's the thing, is that ISO 27001 is security centric. It's not really privacy centric. So even after you implement 001, it's not going to necessarily mean that you're still protected. You have to ask yourself, with who am I sharing data? Because it may be that you've got great security practices in the sense you're keeping the bad guys at the network and all those things. But then if you license your data to some bozo that is not following privacy practices, then you've implicated the law anyway. So there's really two halves of this. You have this idea that, one, you're using proper security and privacy controls. The second one is that you're imposing them on your third parties. So, and if I mean, most of you, I imagine, have had due diligence requests where people say, give me a copy of all of these documents, give me a copy of your SOC 2, give me a copy of this. That due diligence process is what you're essentially using to make sure that your third parties are following what's considered reasonable under the circumstances. That could be ISO 27001, it could be something else. Someone asked here about what about the NIST cybersecurity framework? I think very highly of the cybersecurity framework. I think very highly of the privacy framework. What's important is how thoroughly you've implemented it, and do you have a third party that can say that? It's one thing if you say you've implemented it, it's another thing if your third party assessor or auditor says, yep, you did it correctly. Also, SOC 2 criteria is perhaps SOC 2 criteria best given 5 areas of focus. Here's the problem with SOC 2. SOC 2 is a report, and it's a report that essentially is based upon information you're giving the assessor or the auditor or what have you. So it's only as good as the information you're giving that organization, and it may not be covering all the things that are necessary to be covered. So it's only really looking at what you've proffered to them, what you've given to them. So keep in mind, I'm not disrespecting SOC 2, but it's a report, and it's something that is based upon the things that you're communicating. So it's not the same thing as an ISO 2701 cert or any other kind of cert for that matter. That doesn't mean it's bad. I participate in our SOC 2s every year. Very important, but it's necessary, but it's not sufficient. Other things. So I talked about audits and risk assessments. You will likely have to publish a risk assessment and give that to the California Privacy Police. Keep that in mind as well if you're a significant risk business. And that could be anything that is dealing in special personal information. Also notice that the 30-day notice and cure period will expire at the end of the year, so you will not get a chance to cure, at least in California. And then even if you could cure, okay, fixing the problem that you had originally, putting in reasonable security procedures after something bad has happened does not constitute a cure. So you can't slam the bar door after the horse is gone. Someone has asked, is there value to the ISO 27701 add-on? Absolutely. I did a review. In fact, I did a webinar on that maybe a year or two ago. I like the 27701 add-on. So by all means, if you already have your 701, I'm sorry, your 001, I would highly encourage you to go get the 701. I like it a lot. Again, it's still focused from the security point of view. You're still going to have to address things like licensing the third parties and what they're doing with the data. But aside from that, yes, absolutely. Do these laws specifically mandate third-party risk management? Yes, they do. I will go over that in a couple slides. But the short answer is yes, they do, and they do so in great detail. In fact, in mind-numbing detail. So risk assessments and security. This is the requirement for both CCPA that we have at the moment, and then all 5 laws going live. So notice what's common about all of these folks. You have to implement reasonable security procedures and practices. So again, the controls we keep talking about, but then also appropriate to the volume and nature of personal data or some variation on that theme. So keep that in mind, folks, is that, again, they're not using the word risk assessment, but that's a risk assessment. And if something goes bad and you get involved in litigation, potentially the other party is going to want to see your risk assessment and see what was identified as a risk. Notice again that a lot of these things don't use the word risk or assessment, so don't rely on that whenever you're reading the statute. Also, when there are explicit necessities for risk assessments, some of these laws do mention that. So for example, I mentioned the California Privacy Protection Agency. They're going to ask you for risk assessments if you're a significant risk business. Other laws, you have to do a data protection risk assessment, a DP, basically like a data protection impact assessment, same idea. So in Virginia, Colorado, Connecticut, you have to do that. Notice that if you have targeted advertising, that's one of the things that will necessitate the creation of this. So that's something to think about. If you haven't done a risk assessment that's just specific to privacy and security, now's a very good time to get the budget and get that spun up. There's a lot of work there. I did a webinar on that, I think a month ago. I will probably redo that webinar again in the coming year. These are great questions, by the way, folks, so keep sending them in. Other specifics. So keep in mind that all states already mandate breach notification. So you may be wondering why those mandates aren't in these laws, and that's because all 50 states already have these mandates. They've had them for a while, quite frankly. So including for processors. So if you're a third-party processor, all the state laws tell you you must notify your customer immediately. They use words like without undue delay, but it means immediately. So don't expect to find those mandates in these new statutes. We have a question coming in. Will complying with the FTC safeguards rule protecting NPI also comply the state laws around risk assessments and data cybersecurity? Yes and no. Okay, and I hate to give you a lawyer-like answer for that, but here's the thing. The updates, the FTC safeguards rules are very controls-centric and risk assessment-centric, which is great. So on that side of the fence, yes, they'll do a great job, and they're modeled on the rules from NYC Part 500. So that's the good news. Again, the bad news is that they tend to be security-centric and not rights-centric. So you're still going to have these issues that are going to come up from the rights perspective and third parties and what third parties are doing legally with your data. So this is the hole that I keep talking about. These regulations tend to fall into, is that they talk about essentially bad guys breaking in or hackers or something like that. It's very hacker centric, but it's not stupidity centric in the sense that you have a third party that doesn't know what they're doing, and they're doing all kinds of marketing projects, or they're doing research projects with personal data they shouldn't be. And that's the biggest gotcha I see, rather than just straight up information security problem. Also, all states require businesses to impose information processors. I mentioned that a couple slides ago, and California's is the worst. So here's the list of all the different things, and you might think this is nuts, but this is what you have to do, and it makes a difference between service providers and a contractor. Different definitions. Quite frankly, I have no idea why they bothered doing that, but you have different mandates for service providers versus contractors, and then you still have some versus third parties to whom you have sold data, and now there is a requirement for from consumers. You have to pass along demands to delete that data. So a question just came in. So if my company uses constant contact or what have you, and I prevent them based on their zip code, do these apply to these relationships? So if your company uses constant contact or any tool for that matter to email your customers, and you've provided them based on their zip code, it's absolutely, it applies, because constant contact or MailChimp is still processing that data on your behalf. So they are potentially a service provider or contractor at the worst. So yes, they absolutely have to obey these laws and are subject to these laws. And in fact, if you go to these websites, if you go to Constant Contact or go to MailChimp, I guarantee you'll find all kinds of information there about their compliance with these laws, because this is nothing new to them. So your task list. So again, take a look at your current processing of PI and SPI, determine if there's any significant risk. Still, the best document ever written on the subject is from our friends in the EU. It's called WP248. If you have not taken a look at it, I highly, highly recommend it. It's worth the read. They really do a great job of going into depth and talking about what's considered an elevated or a significant risk. I used it all the time when I was helping companies getting ready for GDPR. So do have a look at that. I think it's great reading, at least insofar as privacy is concerned. Also, review your most recent risk assessment or your audit, whatever you want to call it, and have a look at your gap assessment and your remediation plan. You may have things that you've put off implementing because you are budgeting for them next year. Really take a look at whether that makes sense to bring that forward and to get these things fixed before the end of the year if possible. Also look at your incident response and your breach notification plans. If you've not done a desktop exercise, sometimes they call them field exercises or FTX or what have you. If you haven't done them at least once a year, make sure you're doing them. You would be amazed at the stuff you'll discover. Preparing for them and then executing one, I recommend maybe doing a major one once a year and perhaps even a lesser one. But definitely do your IR and BN plans yearly. Also review your contracts with processors, because I guarantee if something goes wrong on their end, you're going to want to know immediately, and you're going to want to hold them to account. And I know we talked about ISO 27001. The state of California, at least in the past, has offered some admiration for the CIS security controls. So do take a look at those and see if those might be appropriate for you. Finally, we'll wrap up with enforcement here. So the California Privacy Rights Act includes something brand new. So this is the California Privacy Protection Agency, the CPPA. It's a first of its kind in the US. Europe's had these forever, essentially. They've had, so in the UK, it's the Information Commissioner's Office. In France, it's the CNIL. In Italy, it's the Garante. It's these privacy police. And in fact, if you ever watch the ICO, sometimes they will record what they call dawn raids, where they'll go after privacy offenders. They wear the same jackets the FBI does. So it's just interesting how they look at it as privacy police. So we have the California Privacy Protection Agency. They're going to do principal enforcement of the regulations and California privacy laws in general, and then the AG will be the backup, essentially. This agency has extensive power, folks. This is not just a check the box, or this is not just a paper tiger. They can subpoena you. They can also seek a search warrant. So keep that in mind as well, that if you get a subpoena emailed into you from these guys, it means business. They can do administrative fines, and they can also triple the fine if there's misuse of children's data. Okay. Under enforcement, so as I mentioned earlier, AG still has the authority to bring civil actions. If any of you follow the Sephora settlement that happened a couple months ago, example of the AG bringing the hammer down on a retailer for poor information security and privacy. So data collected on or after January 2nd, 2022. So basically the beginning of this year, that's in scope. And the compliance deadline, in the sense that you really have to have your ducks in a row, is January 1st. So at the end of the month. Also, and this is really interesting, that there is a prohibition against retaliating against employees or others for exercising their rights. And the reason I'm bringing this up is because I can see tort lawyers latching onto this and suing companies specifically, or complaining to the AG for this, and then suing under consumer unfair trade practices or something like that to be able to, or just under tort law, to be able to get some kind of compensation. So keep that in mind as well. And then as far as private right of action, for data breaches, that is true for CPRA. You don't have a private right of action for anything else under CPRA. Again, you could arguably use other legal theories, but typically you're going to have a private right of action, meaning that you can hire a lawyer and sue on your behalf for data breaches under CPRA, not so for the other four laws. Also, all four other laws use just the Attorney General's office to enforce the laws. Notice that this idea of a cure period is no longer available for California. There are going to be cure periods for the other states, but frankly, I wouldn't rely on them, because whatever you have, if it's a big enough a problem that's involving the AG, it's probably going to take longer than 60 days to fix anyway. So I would not rely on this. Now is the time essentially to create your own cure period by looking at your audits. The fines can be pretty prolific. So Colorado's can be big, up to $20,000 per violation with a cap of $500,000. Others are just a flat $7,500 per violation, which means per record. So it's not just per instance of something bad happening, but it's per record. So that's potentially going to be catastrophic. Also, don't forget about the potential for injunction. Even if you get a tiny fine comparatively, the injunction you may get, may essentially mandating that you fix everything, could run into multiple millions of dollars or tens of millions of dollars. That's the bigger potential here, and that's something that I don't think gets taken seriously. So enforcement task list, identify documents that are most likely the target of a subpoena. So again, think from a perspective of law enforcement. If you were going to enforce the law and you decided that you wanted to look at the records that are in question, what would you look after? What would you go for? Those are the kind of things that the privacy agency or any AG is going to look for. And I would game that out, if you will, and make sure that you can answer a subpoena or say that we don't have them. Also, get all of your document retention policies, determine if they need to be updated. I almost guarantee that your company is probably keeping documents way too long, and for things you probably don't need them anymore for. So keep in mind that as well, is that now's a very good time to determine whether you really need to keep all that stuff. And then review your HR and ethics policies for anti-retaliation just in general, because this is something you may want to drop in there just to know that you actually acknowledged it. Okay. So wrapping up here, the most common failure points that I've seen in my career, I've been doing this since about 2003-ish. Starting too late is a big one. I find that folks wait way too long and they realize they're in over their heads. Assuming you're exempt. Yes, many institutions are exempt from these laws in the sense that they're governed by federal law. So they're governed by GLBA or HIPAA, high tech, or what have you. But those institutions have plenty to do anyway. Not identifying in-scope data. So the idea that you're not really identifying things that are in scope in the sense that you think the data is maybe too trivial or it's quote unquote transaction data. This is a bit of folklore that I hear that, oh, this data is not in scope because it's transaction data. There's no such thing as transaction data as far as the law is concerned. If you can identify someone or potentially identify someone, it's in scope. So just keep that in mind. I don't know where these mythologies come from, but if it can identify someone, it's in scope. On taking a risk-based approach. So these laws have to be obeyed. Way back when we were dealing with laws that could be, for example, PCI DSS or other things that are like a law like PCI, you take a risk-based approach. You put in the kind of controls in place that are commensurate to the risk, whatever you've identified as a risk. Here, that's not the case. If someone asks for the data, you've got to cough it up unless you can find a legitimate reason not to. So keep that in mind. Just pull out the whole idea of risk-based approach. It really is all rights-based. By not engaging in all the necessary team members. So one thing I find is that important team members get left out of discussion. Product marketing probably should be at the top of your list, believe it or not. I know typically people think, oh, well, HR should be. But I can tell you, product marketing is going to know where all the personal data is being collected from your customers, how it's being used, what devices are showing up in its use. So keep that in mind that you want to get all the proper people on the team. Not having a system to track requests, you've got to be able to have some kind of organized system to track it. Don't rely on cures, and your third parties are always a problem, as you probably know. I have a question that just came in. Does GLBA require data classification that covers these? GLBA, well, it's funny you mentioned that. GLBA mentions data classification in the Federal Register. It mentions it, and it says that you have to use it, but that was really in the introduction to the new GLBA controls. So GLBA is mentioned in the Federal Register as, yes, requiring data classification, but for whatever reason, they didn't put a specific control saying use data classification. When in doubt, use data classification. I'm a little bit biased, but that's what I recommend. So in the minute that we have here, keys to success, folks. Understand what qualifies as in scope, where it is, who has access with it, and what they're doing with it. If you're short on time, think about the 80-20 rule. 20% of the systems that you likely care about, 80% of the data that you really want to be able to account for. Do leverage the cybersecurity and the privacy frameworks, folks. Don't forget the privacy frameworks. It's not just CSF. CSF is great, but don't forget privacy. It's also an excellent one, and it mates up well with it. Learn from others. I look at these every day. They are endless entertainment, folks. Definitely check them out. You will find all kinds of great things not to do. This is an example of a data inventory I did some years ago, still relevant to this day. You can see some of the different data elements that are in scope. So I wanted to share that with you. And finally, do visit our Privacy Please podcast if you have an opportunity. And that's what I have for you today. So if you have other questions, you can feel free to email me. I'm always happy to answer questions. I can't give you legal advice, but I can just give you the view from 30,000 feet, if you will. And so with that, thank you all for joining us. Oh, will I be sharing this presentation? Yes, absolutely. You'll be getting a copy of this and also the state-by-state comparison I've done as well. So you'll get all of those things as well. So that's it. Thank you all very much for joining me today, and look forward to seeing you in a future webinar.